Ms. Haney, your jury selection expert, and your other colleague, Miss. Will you introduce her for the record again?
Yes, Your Honor. Lauren Childers. She is a member of the bar of the state of Texas. Has not yet prohack VJ. I'll try to remedy that.
I'm allowing you to do that now. The California law in a capital case allows each side to have 2 lawyers. Mr. Durst has more than 2 lawyers. Mr. Durst has 4 criminal lawyers and additional lawyers. And I've made space for you, even though there is no legal requirement for me to do so. The people also have counsel, and the people are equally represented with 5 attorneys. So when I describe these circumstances to you as a courtesy to everyone, so that you could prepare, so that you would have a place to put your files, so that you so I could do everything possible for you under these circumstances to optimize your ability to represent Mr. Durst. You did inform me that you objected on the grounds of public trial. So, and you're objecting to these circumstances. You feel that they constrain your ability to represent Mr. Durst, but I've explained I only have 40 seats, and though there is a case about public trial and representation, in re Oliver, 333 U.S. 257, that's a 1948 case at pages 271 and 272. Mr. Oliver didn't have 1 lawyer. He has here, Mr. Durst has not only 1 lawyer, but 4 lawyers. If he didn't have 4 lawyers, I'd have space for additional members of the public. There isn't necessarily a right to have more than two lawyers, and even that's if I define a capital trial as a trial in which the defendant could have faced the death penalty. So it's not even clear that there's a right to more than 1 lawyer, yet I provided you with this seating. I do want to add the public has access to this trial through our audio courtroom attendance program. Our court's website describes how that is possible. We have televised media, at least 1 physical public seat. Mr. Durst always has had supporters in the audience. They have always been his lawyers, Ms. Ames, Mr. Garcia, and because they're lawyers, I'm giving them permission to sit up front. So there is space. So I am giving priority to individuals designated by the defendant following in re Oliver and People v. Scott, 10 Calap 5th, 524 at 5:30. And I do believe televising the trial, making live audio available upon request is enough to make this a public trial. There is a physical seat for the public. I find there is no additional space in the audience. The jury is using the balance of those spaces. I also want to note that it's not just the defendant's right to a public trial. It's not just the defendant's right that we admit the public. It is the public's right to be at a trial. We're making that available first come, first serve, or by lottery. The defendant's constitutional right to a public trial includes the right to have friends and relatives present, People v. Scott, 10 Calap 5th, 524 at 5:30, but the defendant does not have a right to present an unlimited number of supporters, and the court may make reasonable restrictions. People v. Esquivel, 166 Calap 4th, 539, 552, 553, and under Esquivel, reasonable limitations may be imposed. These are reasonable limitations that I have described. It's recognized that courtroom access may be denied or regulated by reasonable time, place, and manner restrictions in order to maintain dignity, decorum, or when courtroom capacity precludes entry by every person who wishes to attend. That's NBC subsidiary versus Superior Court, 20 Cal 4th, 1178 at page 1222, footnote 46. Pardon me. So I am prioritizing access to the defense. I have made reasonable efforts to support you. As conditions change, we may be able to make additional accommodations to you. Let's talk about the emergency motion to continue, as you have called it. You've made an emergency motion to continue, which you have I guess, distributed publicly so that everyone can see that, and that's fine. So, Mr. DeGuerin, you made your argument, and you attached the doctor's letter, and those the practice of this court when receiving a last-minute continuance is recognizing that the other party, having witnesses who are traveling, witnesses who have made commitments. I issue tentative rulings every time, and I informed all counsel. My tentative ruling is to deny your motion. So if you wish to add to your motion what you wrote already, which I read, you may add to it.
You may respond to the first part of it, though, Your Honor, about continuing or going forward with the trial. As the court so accurately observed, we are still in this pandemic. There's no reason to risk all this and to thereby punish the defendant by not having his lawyers able to consult with each other in trial. There's no reason to go forward now. We can wait until this pandemic, which is now resolving, but is not yet resolved, is over. So that's my response to that. If you want me to address the medical, I will.
You may add as you wish. I read the letter. If you want to further describe it, you may, but I read it. It's in the record.
I want to make a correction to one part of our motion where we said that he was not being treated for the cancer. He is being treated, but he's being ineffectually treated, and that is obvious from the doctor's opinion. He was receiving 1/3 of the treatment for the cancer, and that has been ineffectual, and he is thus effectively not being treated. That is a statement that was made in the motion, not in the doctor's opinion, not in the doctor's letter.
All right, let me.
The doctor said that he is in need of urgent hospitalization. Urgent hospitalization, Your Honor. This is not something that's made up at the last. You know from observations that when we were in trial and when we were in hearing, Mr. Durst frequently had difficulty. We, in fact, obtained an order from you about 2 years ago for him to be examined because of things that happened in the courtroom and his health. They've gotten much worse in the last year, much worse. And we have observed it. The lawyers who have visited him have observed it. And as you know, we started to get collectible records. Ex parte asked the court for an order to do that, and it took a while. Dr. Klein was kind enough to work very hard on reviewing thousands, 30 or 40,000 pages of medical records to arrive at his conclusions. His conclusions include, first, that he is severely malnourished, and that is a secondary to his esophageal cancer that was resolved but has reoccurred. He is in atrial fibrillation and being untreated for it. I'm advised that they do not have it on anticoagulants, and that is per se malpractice, that he is not on an anticoagulant but is an AFib.
So your this material, I think, goes to a second part of your motion. So you made an omnibus motion. You moved to continue. You moved to release Mr. Durst on bail, and you also asked for a hearing on the due process nature, or the due process considerations of all these afflictions that you are describing now.
And also that he be admitted to a hospital, whether it's by being admitted to bail and going into a hospital, or whether he's admitted to an actual hospital and treated by someone other than medical students, Your Honor, who records reflect that he's not being treated by board-certified physicians.
So here's my point, is notice, Mr. DeGuerin, because 2 days before trial, you've given this elaborate medical presentation in support of this omnibus motion, and I appreciate the documentation you have provided, but a motion to continue does require 2 days' notice. So I can hear today the motion to continue, but as far as a motion for release on bail, a motion for, you say there's a motion for hospitalization, although that's not exactly my jurisdiction, but because we do entrust our persons in custody to the medical care, excellent medical care, I will add, that Los Angeles County Sheriff very much underappreciated. I am awaiting a report from them about his condition. I saw your motion. I wanted my own report. But as far as a motion to continue, we have jurors coming in about 10 minutes. All right? I'm going to welcome those jurors. I'm going to speak with those jurors. But let's just address this motion to continue today. All right? What can you say about continuing today as opposed to, by its nature, your motion calls for 10 days notice. California Rules of Court 4.111. Mr. Ray is very familiar with that as a California lawyer. To hear it sooner, there must be a motion to shorten time. Though this is labeled an emergency, I received no motion to shorten time. So we will hear the first part, which is the 1050 motion. Do you have anything else to add on that motion to continue today?
Your Honor, I received Your Honor's email that said that you were going to deny the motion, and so I called
the first part. No. I said part one, motion to continue, tentative denial. The rest of the motion may be heard. You may have a hearing. I'm interested. I care about Mr. Durst's health. I want to hear about it, but there also must be notice so that the other side can respond.
We filed this, I believe, Thursday, Your Honor.
Yes, 2 days' notice is sufficient for a hearing today on a motion to continue, but all of the rest of it needs 10 days. That takes us 10 court days. So that's next Monday. We might be able to do it sooner than that, but not today.
I took your email, Your Honor, as indication that we would not hear Dr. Klein, so I called him off. I can get him here.
No, not today. He may not testify today. We do not have time for Dr. Klein today.
All right. Well, that's what I wanted to say. I would have had him here, but for that email. And Dr. Klein, is available. I can get him, but we've got to give him notice also. I think just a few hours notice is enough for Dr. Klein. I want to put in the record, in this record, even though the motion and letter is on file, I think it's important to put in the motion at least the very serious, debilitating conditions that he had.
I have your record of that. You may repeat, you may summarize.
I'll summarize it. His hydrocephalus has returned according to the symptoms, which are symptoms of the hydrocephalus. That's a very serious condition. He needs a neurology consult and a neurology examination by a board-certified neurologist, not a third-year medical student, which is all he's been getting. Yes, the jail does their best, but they're limited, Your Honor. The doctors that he's sent to see are medical students. The nurses they're nurses on call, but they're not doctors. He has chronic kidney disease and is subject to renal failure, which is a life-threatening matter. He probably needs to be on dialysis, but he needs another consult. He has coronary artery disease that has increased. That puts in that in his AFib, putting it in risk of a stroke, and that's what he has lung disease, COPD, lung disease. He's very difficult to breathe. He tires easily. Anecdotally, when his lawyers go to see him in the jail, he's good for 45 minutes, maybe an hour, and then he's too tired to go home. He spends more than 90% of his time on his back in a bed, a hospital-type bed. He's anemic. He has spinal disease. He has kidney stones. It's a myriad of conditions. This is something that's very serious, and the doctor simply says the question is not whether he can endure the rigors of the trial. The question is whether he can survive it all.
So, Mr. Guerin, I'm aware of these concerns. I do take them seriously. I will give you a hearing. I will be guided by People versus Avila, which did address this situation. But I'm going to hear from Mr. Lewin about if you will identify for the record the concerns of the people or burdens upon the people should I continue this trial. I'm going to cite in my decision 1050A and the preamble to 1050A, which explains the considerations the court must take when presented with a motion to continue on these grounds or any grounds. You may be heard.
Yeah, of course, Mr. Nominee, because with the media, et cetera, in my computer, I'm going to remain seated where I can see my computer and the media can't, with the court's permission. Is that okay with the court, Your Honor?
Yes, you may.
So I want to start by, first of all, addressing very briefly where we are in terms of the status of the case, because it's important. The defense has made mistrial motions from basically the day we started jury selection prior to the pandemic. They have made motions for mistrial, by my count, on at least 5 different and completely independent issues. On Tuesday of last week, they were denied their writ by the Court of Appeal on their latest request, trying to get the court to reverse the court's denial of their mistrial. The Court of Appeal not only denied their writ, the court actually stated, which they did not have to, that the court had not abused its discretion at all, and cited the very case that the court cited. In essence, removing this issue, not only with respect to the writ, but post-conviction as an appellate issue as well. So 2 days after that, we get this quote emergency motion. However, when you go through the quote emergency motion, almost all of the material that is included goes back months, if not years, and the defense has done nothing. We've never heard about this before. We find out that Dr. Klein was retained, by my understanding, within the last month. We find out when we review his report, and again, and I'm glad that Mr. Guerin clarified, I'm going to clarify a little more. The headline, when this motion was leaked to the media, was that...
But this was a publicly filed motion.
Yeah, that's... Thank you, Mr. Guerin. Yes.
I was contacted by the media prior to the motion being filed. So I don't know, of course, since I don't speak to the media during the pendency of a trial, but that's what happened. So in any event, the motion was filed, and at the time that they filed this motion, they list all of these medical issues. Now the headline that took place was, Mr. Durst has bladder cancer and is not being treated. In fact, and I have Mr. Durst, I have a nice clip that I'll get to at some point, but Mr. Durst discussing the excellent care that he's getting in custody and how they found his bladder cancer and treated it. That goes back, I believe, to 2018. I'm very glad that Mr. DeGuerin, at my request, cleared up that issue in their motion. But to have the headline out there that in essence, the Sheriff's Department and the county is letting Bob Durst die is absolutely false. It's not misleading. It's not up to interpretation. It's false. It's a lie. It's untrue. I'm glad it's been clarified. Let's get to the next problem. Mr. Durst is not being treated by, quote, medical students. That's untrue. He's being treated by residents. Residents are doctors. They are under the supervision of attending physicians. That is what happens when you are in a hospital, a teaching hospital, which County USC is one of the best in the world. Now, they have outlined in their motion a number of issues, which I'm not going to go into, but I just will say this. Their own expert, Mr. DeGuerin, just said that Bob Durst needs dialysis now. This is quoting from their expert's report. The decline in renal function over the past 10 years has been extreme, and a very conservative trend line indicates he will need dialysis in the next 1 to 2 years. So it's very important that when arguments are made, that they be made properly, that they be made honestly, and that they be made accurately. Now, the situation... So, as we examine and we go through the litany of complaints that they have about Mr. Durst's medical treatment, most of those things go to the specifics of how he's being treated, issues which have been ongoing and which should have been pointed out to the court, most likely ex parte, in the years that he has been under treatment. Just so it's clear, he is living, Your Honor, in what is in essence a hospital bed in a medical unit. He is at the very top of the quality of care that can be given in the system. Now, there's no question that with Mr. Durst, $100 million, he could probably afford the best care at the best hospitals in the world. Unfortunately, he's been charged with capital murder, and he's in custody with no bail. So I wanted to get that out first because these are important. Now let's talk about the continuance issue. Obviously, we are in a position where we have had to schedule numerous witnesses, and we've had to do this at 2 different times. I have doctors who have already flown out from New York, some of whom are already here, some of whom are leaving today, who have to testify on certain dates. If there were a continuance in this case, number one, we have witnesses who are not available. We don't know if that happened. We would have to start over from scratch, picking a jury under pandemic circumstances when that would be. Now, what the medical report doesn't address is, and what is very clear, is that in essence, what the defense is asking for is we want a continuance, we want the trial stopped, and we want Mr. Durst hospitalized. There is no one who is going to come into court and say, you know what, I think in 6 months or in a year, it is probable that Mr. Durst will be healthier than he is now. One of the problems is he's a 78-year-old man. Now, Mr. Durst had cancer almost 20 years ago. And doctors, if you had reviewed his reports from 2002 and 2003, the idea that he would still be alive today, many doctors would say, oh, you know what, Mr. Durst is not likely to be living 3 years from that point. We're now almost 20 years later. So one of the problems is that in essence, what they are asking for is they are asking for Mr. Durst to be trial stopped and freed from custody to be put in some private hospital. First of all, as the court is aware, it's a no bail case.
I'm not hearing a bail motion now.
Right.
There's not sufficient notice. I wanted you to outline the conditions, the burdens upon people's witnesses in particular, as 1050 specifies. It's 10:04 a.m. and I appreciate all of your arguments as I appreciated Mr. DeGuerin's. But I wanted you simply to identify those factors so I could rule on this. We'll have a subsequent hearing on the issue of whether he's too ill to be prosecuted. It will not be today.
And Your Honor, and we're going to ask when we schedule that motion, because of certain time restrictions that we have, we might ask that this get put over, meaning the motion, a couple of weeks so that we can adjust our witnesses who we've already have coming and are flying, etc.
I'll do it on a Friday.
Perfect, Your Honor. Thank you.
But we're not scheduling that. Oh, if that's a
Can't be
problem.
here Friday.
Pardon me?
I cannot be here Friday.
Not this Friday.
A Friday.
A Friday. So the people of, I've already identified, I think, these issues. Mr. Lewin, it would be burdensome on witnesses, extremely burdensome on witnesses. It would be burdensome to delay our jury any longer.
The expense,
I'm going to weigh these ideas.
the expense that is involved, that has been put forth in terms of bringing these witnesses out, the inconvenience, it will be 2 different times where I've had doctors rescheduling patients, et cetera, back a year ago when they were scheduled to come out, and now again today. We have issues regarding availability of our investigators. Most of the investigators who started on this case, they are just about all retired. They've left. We have new investigators, and we are trying to balance and keep everybody in a position where we have access to them. In addition, we have other witnesses, due to their age or health condition, who are going to be called, where there are issues there regarding their ability to be present, some of whom have not been conditionally examined already. So when you add all that up, the absolute burden that would be placed upon the people, the court, etc., for a request, which in the end is simply a get-out-of-jail-free card, because we would never be able to try the man. There's not 2 systems of justice in this county, one for rich people and one for everybody else. Mr. Durst is in custody and getting the best treatment possible that they offer at County USC, at the medical center, at the jail. If Mr. DeGuerin wants certain things done, then what would be appropriate would be to have ex parte communication with the judge, requesting that Mr. Durst be seen by various experts and specialists. That should have been done much sooner than 2 or 3 weeks before trial. And the timing, coming 2 days after the latest denial of the motion, would cause anybody who's reasonably looking at it to think that the goal here is simply to have this trial go away.
Thank you.
So,
1050A of the California Penal Code states the welfare of the people of the state of California requires that all proceedings in criminal cases shall be set for trial and heard and determined at the earliest possible time. To this end, the legislature finds that the criminal courts are becoming increasingly congested with resulting adverse consequences to the welfare of the people and the defendant. Excessive continuances contribute substantially to this congestion and cause substantial hardship to victims and other witnesses. Continuances also lead to overcrowding and increased expenses of local jails. It is therefore recognized that the people and the defendant and the victims and other witnesses have the right to an expeditious disposition, and to that end it shall be the duty of all courts and judicial officers and of all counsel, both for the prosecution and the defense, to expedite these proceedings to the greatest degree that is consistent with the ends of justice. Continuances, according to Part E, shall be granted only upon a showing of good cause. G1 states, when deciding whether or not good cause for a continuance has been shown, the court shall consider the general convenience and prior commitments of all witnesses. Here, there's a description of difficulty in working with Mr. Durst and preparing him. The defense has had at least 5 years to prepare for every contingency in this case. Second of all, there is no evidence that Mr. Durst is mentally incompetent. Indeed, his letter to this court clearly demonstrates his cogent thought. Third, a physical disorder does not necessarily result in mental incompetence or mean the defendant is not present. People versus Avila guided a court in a guides this court (117 Calap 4th 771) at 781. A similar claim. Adoption of defendant's position renders individuals suffering from chronic ailments or painful infirmities essentially immune from criminal prosecution. This would be untenable. Goes on, where the defendant suffers from a chronic condition causing pain and associated symptoms, but he or she is lucid, coherent, and rational, the trial court is not obligated to suspend criminal proceedings. Rather, the proceedings are to be conducted in a manner that reasonably accommodates the special needs of the accused to the extent this is practicable in light of courtroom security considerations and other legitimate constraints. Good cause has not been shown. There will be, the court denies the motion to continue today. I will grant a hearing on the medical issues that have been described. I do want to hear the parties out on that point. To that end, do the people seek to examine the defendant also?
Yes, Your Honor.
Well, I may have to order that. Even the health is placed at issue.
Your Honor, I would also request that the court make an order. There's an issue with talking to the physicians at the medical center who are basically saying that due to HIPAA, they cannot discuss Mr. Durst's situation. My belief would be that they have waived that with the submission of their motion, and there is no way for me to adequately do my job without being able to discuss Mr. Durst's situation. Will the court make an order?
You put it in writing. Make your motion in writing. Okay, next, because jurors are arriving now, they're probably all here. I want to address the proposed questionnaire and examination of these jurors. So as to the proposed questionnaire by the defense, I've already heard the argument. I've already denied the request for a questionnaire to jurors. Now, in written form, the defense motion for a questionnaire April 19, 2021 identifies specific questions the defense claims they have a right to ask jurors directly or in questionnaire form, or in the alternative to have the court ask. I'm denying, again, I'm reiterating it. I'm going to add these reasons. First of all, the defense brief misstates the law. The brief that I was given states the rule for voir dire to members of the veneer under Code of Civil Procedure 223 and 225. The defense says these statutes make it mandatory for me to allow questions by counsel. But the applicable law that governs removal of seated jurors for cause is Penal Code 1089 and Code of Civil Procedure 233. These standards are different. The cases and statutes the defense cites and most of the questions they've written have no lawful place under the current circumstances. Jurors are presumed to follow instructions. To paraphrase Justice Holmes, it may be assumed that a jury does its duty, abides by cautionary instructions, and finds facts only because those facts are proved. Akins versus Wisconsin, 195 U.S. 194. And just 2 months ago, the Second District Court of Appeal reiterated this. Reopening voir dire of seated jurors requires a showing of good cause. Speculation that good cause exists is not sufficient. Good cause is required, not speculation. People versus Byers, that was March 1st at page 8. Secondly, the questionnaires are intrusive. The court has a duty to protect jurors' privacy. Town Cell versus Superior Court, 20 Cal 4th, 1084, 1094. Third, the questionnaire very obviously encourages jurors to avoid responsibility by suggesting excuses. The Heisenberg phenomenon, roughly restated, is when the observer affects the observed. That's what this questionnaire does, considered from the most charitable and diplomatic perspective. If someone were to design the ideal questionnaire to cause a mistrial, this would be it. It's appropriate for the court, though, I believe, to make an inquiry regarding the jurors' fidelity to the admonition they have received 12 times during their absence. Aside from that, the motion is denied. Now, counsel, I intend to welcome the jurors and inquire of them. One, have they read or listened to or watched any news commentary about the case from any source? Have they discussed the case with anyone else? Second, any health concerns which could affect their service. Third, whether there's any new and different extreme hardship that would prevent their service I'll ask them to write down any yes answers. I will follow up any comments with questions. I'll present them to you for your guidance, and that's what I will do with these jurors. Yes.
We'd like to ask the court inform us of all communication
Yes.
between the jurors and the court,
Yes.
particularly those that come from the jurors.
As I do at each time we're on public. It's my duty to do that, and I do. And we have one. I'm going to tell you, except I don't have much time.
Well, of course, we know of two regular jurors, one alternate that we've had, that the court has informed us about. We don't know of any other communications from the jurors.
Yes, there is one more. And there's one that's not of substance saying, so we come in on we're still coming in May 17th at 9 o'clock, and then I had all the jurors informed we were delaying until 10 o'clock. So, but there was one of substance, a juror, (3090). The jury inquired of RJA, essentially, what do we do if we think Mr. Durst's statement used against him was obtained unlawfully or unfairly? So that's not a question, that's a question that calls for an instruction. And since the juror brought it up, we'll talk about how I would instruct all the jurors. But you should know that that person is the source. So that's it. All right, the jurors were admonished. I admonished the jurors April 14 and May 12. I repeated the entire admonition, and they received instructions about reporting here. We have additional issues to discuss, but I want to welcome our jurors. So we will, I am going to adjourn, but we have issues about the opening statements and about a hearsay ruling I wished to discuss again. It bears upon opening statements, so before we leave today, I'm going to discuss it with you.
Your Honor, I don't know whether my co-counsel, because I can't talk,
Yeah.
got what you said about the juror who had written the note.
Yeah.
I did get it. So you
They got it?
Okay.
Your Honor, two things. I assume the court is going to let us know, obviously, the juror does not make determinations about the legal admissibility of the statement.
We'll talk about how to instruct.
The second issue, and this was Mr. Lewis's suggestion, which we would join in, and Mr. McGarrett agrees as well. I know the court cannot say to the jurors, have you been vaccinated? But the court can certainly tell the jurors, with our permission, if everyone is agreeable here, both teams, start to finish, on both sides, have been fully vaccinated. And if the court wants to let the jurors know that, for their peace of mind, I know I've spoken to counsel, and they're willing as well, and we're willing if the court is.
Correct? Okay, Mr. Lewis is nodding, Karen, right? I'll tell him, I'm going to talk to him a little bit about how I was vaccinated. I want to encourage people to be vaccinated, but I don't want to intrude on privacy either. So I'm going to, but thank you for giving me that permission. That's something that I did want to share. I appreciate your forethought. Right? Let's then recess until the jurors come in. We may have Mr. Durst. I doubt it, but.
Your Honor, how does the court plan to, if in fact Mr. Durst does not end up coming to court, is the court's position is to say he's going to be extracted if necessary, that in essence he will be here for the jury?
Yes.
Okay, thank you, Your Honor.
Yes, but today, if he's not, I'm going to be doing the talking, really. I'm going to talk to the jurors a little bit. I'm going to ask them 3 questions to write down, and you get the answers. So I don't think that's anything. I mean, he's not missing that much.
Well, the court's made the finding that he's voluntarily absent.
I could. I mean, I have a report from the sheriff that that's what happened, but we'll have a hearing. I mean, as needed. Again, I don't want to get to matters of substance. To some extent, this was substance, but it's also it's not critical, but there are legal arguments that had to be heard and decisions that had to be made now. So either way, even if it turns out the sheriffs were wrong and he really did want to come today, then still, it's not, I don't think it's prejudicial to him. We're going to take a recess, and let's get our jurors in here. And we have seats, folks in the audience, and I regret I can't keep you here, all of you, because we have, our jurors take up 22 seats, so. So please cooperate with when we clear. You can listen to the proceedings. They'll let you know how to do that. So, all right, we'll be in recess.
One minute.